Yes, so maybe we could start there, but I think before we go into victim or perpetrator, I remember the last time when this was starting, the trial was starting, a lot of the victims' families were glued to the TVs and said, as much as we want to know where this story starts and ends, will we understand the process at the ICC? Will we understand how the law works there? So talk to us about the process there.
Well, the trial of Dominic Ongwen commenced on December of 2016. Before the trial started, there were pre-trial proceedings before the pre-trial chambers of the ICC in respect of confirming the charges.
Okay.
Remember, when the arrest warrant was issued, it was only in respect of one attack in one IDP camp. And so when Ongwen was eventually surrendered to the ICC, there were pre-trial hearings that expanded the scope of the charges against him.
Yeah.
When the charges were confirmed, the formal trial began on December of 2016. The expectation of many of the victims was that this was going to be a trial in which the victims would be front and center.
Yes.
And so many victims, especially in northern Uganda, thought that all of them were going to be called and involved in the trial. And so I think they were, in the initial stages, quite disappointed by how far removed the trial is, irrespective of the efforts of the ICC to create some sort of link so that people can watch it through a video. They were quite disappointed at what they saw. And as such, many victims up to date, I don't think feel that their interests have been taken into account in that trial.
Have they, though?
They have. There's a process in which this case had to undergo to identify the victims who would participate in the trial.
Okay.
Because the case against Dominic Ongwen is a very limited case. It was not a case against the entire rebellion in northern Uganda. So there are many more victims than the specific remit of the charges against Dominic Ongwen.
Right.
So only 4,100 victims were certified and permitted to participate through victim lawyers at the ICC.
Okay.
So as far as the 4,100 victims are concerned, their interest has been presented in that court. But the victims of the entire LRA conflict, I think, are still awaiting for their day when their needs will be addressed.
So perhaps it wasn't the answer they were all looking for.
No, it wasn't. It wasn't really. The remit of the case before the court was very limited, and only a few victims. Because to claim victimhood, you must show the nexus between your victimhood and the case before the court. And the case before the court is only in respect to a few incidents in northern Uganda, and so many victims were not part of the case.
Okay, so victim or perpetrator, I mean, they have argued that at the end of the day he was brought in as a child, trained by the environment and the situation to become who he did become. That holds up in court, right?
It does. The thing, though, is that you've got to look at the entire proceedings and the filing done by the Ongwen defense team to understand what kind of defense they want to raise.
Yes.
At the very beginning of this trial in December of 2016, they raised the question of mental fitness to stand trial. In fact, the court had to go back into a trial within a trial to determine whether Ongwen was in the right mental state to stand trial. The court determined that he was in the right mental state to stand trial. But the court did something significant. The court also appointed a psychiatrist so that the psychiatrist can, on a continuing basis, assess the mental status of Dominic Ongwen throughout the trial. Now, the defense has indicated very clearly that part of the defense is that Ongwen was not in the right mental state when he was in the LRA.
Okay.
In fact, they've lined up two psychiatrists, Dixon Akena and Ovuga Emilio, to testify to that. It would be interesting to see what they will say. The second defense they're trying to raise is the question of duress, to say that the things that he's alleged to have committed were things that he did under duress, because the method of retention by the LRA was use of force. And they've lined up Kony's ex-wife, ex-combatants who are now working for the UPDF to testify to that. The third defense they intend to raise is the question of alibi in specific reference to the charges on the attack on Jule IDP. Remember, the first 10 witnesses of the prosecution spent a lot of time on the attack of the Pajule IDP in October of 2003. And so he wants to claim alibi, to say that those attacks happened, he wasn't there, he wasn't involved. So the defense is now clear what they want to, to put forward. The last one is the question of being a victim. It's a fact that Mr. Ongwen was abducted by the LRA as a child.
Yes.
And that they want to argue diminished responsibility on account of the fact that he was forcefully recruited into the LRA.
Okay, so it's just the start. This can go on until what years?
Well, what happened today was the opening statement of the prosecution. On 27th of this month, the real presentation of evidence through witnesses will then start. The prosecution presented about 69 witnesses, and this took them 22 months. That's nearly 2 years. Judging by the number of witnesses Mr. Ongwen has said he would have in court, you're going to have at least something close to 2 years of a trial. So it's not going to be a short trial.
Wow, something to definitely keep following. Thank you so much, Nicholas Apio.
Great, always a pleasure.
That's it for Newsnight. We'll take a short break.